If you or a family member is concerned about needing skilled care in your latter years and preserving those assets that you've worked so hard to accumulate over your life, then you'll want to take the next few minutes to watch this webinar on protecting your family's assets from Medicaid spend down and recovery. Hi, my name is Neil Angel, and as a financial advisor in upstate South Carolina, I've helped many families to preserve their assets from rapid depletion in the face of skyrocketing nursing home costs. The good news is that even if you have not purchased long-term care insurance to protect against this financial storm, you still have options for protecting your family's assets from the state. If you're serious about this, then I would encourage you to spend the next few minutes and follow along closely. If your loved one needs to apply for Medicaid assistance to pay for long-term care, do you know the rules for Medicaid spend down and recovery? Do you know what assets are subject to recovery by the state? And do you know how much your parents are allowed to keep in assets when applying for Medicaid? And how long they have to transfer assets without incurring a penalty? These are critical questions to understanding the rules for Medicaid spend down and recovery and protecting yourself and your parents' inheritance at the end of the day. For starters, there are a number of important considerations, not the least of which is whether or not you own long-term care insurance as a backstop to protect your estate in the event that you need care. But even if you don't, do you have money designated to pass to your family or charitable organization? And do you want your family to pay taxes on the money that they receive? Let's start by taking a look at Grandma's story. Grandma actually did her homework beginning in 2001. As a matter of fact, she hired a financial advisor to help her structure her investments and an attorney to help draw up a will and powers of attorney in the event that she was incapacitated. But unfortunately, in her planning, neither talked to her about long-term care issues or how to protect her assets way back then. The attorney prepared a will, and the financial advisor sold her an annuity in life insurance, but it stopped there. In addition to the annuity, Grandma designated a $100,000 CD at the bank as an inheritance for her granddaughters when she passed away. And so she placed her account as payable on death in order to avoid probate, so that each would inherit half when she passed away. But what she didn't realize is that the POD designation only bypasses probate. It doesn't actually protect from the nursing home. And so that money was subject to Medicaid spend down. Grandma really wanted this money to be a blessing to help her granddaughters get ahead with their life by helping them pay off their college loans from the CD money. But in 2007, she was forced into a nursing home because of declining health. At that time, she did not own a home, but she did own almost $300,000 in liquid assets. Unfortunately, the nursing home cost some $9,000 a month, or over $100,000 a year. So in just 2.5 years, all but $2,000 of the money had been spent down, including the CD money that she had designated to go to her granddaughters. When she entered the nursing home, if you recall, she had almost $300,000. However, the nursing home costs $9,000 a month. So if you divide 9,000 into 300,000, you come up with about 33 months. So in 33 months, her assets would have been spent on the nursing home. And then she could apply for Medicaid once she had spent down to $2,000. If she had just put her money that was designated in the CD into an estate trust back in 2001, the estate trust would have been Medicaid exempt after 5 years by 2006. So why then did Grandma lose everything? Well, when she entered the nursing home and applied for Medicaid, the CD was still considered an asset in her estate, and she was required to spend all but $2,000 of her estate value to apply for Medicaid. The lesson is this: without proper pre-planning, all assets can be wiped out if Medicaid ever becomes an issue. Grandma would have been far better off using an instrument known as an estate trust for inheritance purposes rather than parking her money in a CD down at the local bank earmarked for her granddaughters. First of all, the assets sitting inside of an estate trust are Medicaid exempt after just 5 years. And because they don't require probating like assets under a will, The granddaughters are not required to incur attorney fees or court costs, and they can receive the inheritance automatically upon her death. And because the assets sit inside of a life insurance policy and the death benefit increases, the value of the inheritance increases over time and passes along tax-free to her granddaughters. Because the estate trust is irrevocable, it must be Medicaid exempt according to the law. And fortunately, the estate trust can be established without incurring additional expensive attorney fees, unlike other types of trusts. Each spouse can fund an estate trust of up to $100,000 or up to $200,000 if they use multiple insurance carriers. Bottom line, peace of mind for the family. So the $64,000 question is, what if Grandma had done an estate trust rather than the CD? So what would have happened with an estate trust? Well, again, the money would have passed to her family or a charity tax-free. There would have been no additional setup fees required because no attorney required. The assets would have been Medicaid exempt after 5 years, and she would have had the peace of mind of knowing that her family would enjoy their inheritance regardless of what happened with her need for nursing home care. You know, a little pre-planning could have made such a difference for her granddaughters when she passed away. If she had just known about this and had been properly advised by her attorney and her financial planner, what a difference it would have made. Instead of leaving nothing, she could have left $109,000 upon her death to her granddaughters to help them pay down their college tuition. And it would have been Medicaid exempt after just 5 years. Well, I can hear you say that may be well and good for some families, but for our situation, that's just not going to be an option because we're facing the prospect of nursing home well within the 5-year limit for Medicaid spend-down purposes. So what options are available for us? Well, the first thing I would say is consider protecting the assets that your parents have designated for their funeral costs from Medicaid spend-down. And realize that if they own a life insurance policy with more than $2,000 in cash value, then those assets may be subject to Medicaid spend-down. But there is a way to solve that problem. And that is by considering setting up a funeral trust where the money transferred inside of this trust is immediately exempt from Medicaid spend-down. Your mom or dad probably purchased life insurance policies years ago for the express purpose of paying for their funeral when they pass away. But what they may not realize is that if they have to look to Medicaid to help support them in their latter days for nursing care, then that money may be subject to Medicaid spend down, particularly if they own policies with more than $2,000 in cash value. Fortunately, the states have made provisions for you to set aside funeral trust funds that are Medicaid exempt for spend down purposes. And you can set aside up to $15,000 inside of these funeral trusts. And actually, it's a great way to become eligible for Medicaid sooner by doing that. When it comes to using funeral trusts for final expense versus other savings alternatives, namely money in savings accounts or CDs or proceeds of annuities or whole life policies or even pre-need agreements with the local funeral home, funeral trusts win on a number of accounts. First of all, they're not subject to judgments from lawsuits. They're protected from liens from creditors. They're not subject to income tax on the death benefit. And as I mentioned earlier, they're not subject to Medicaid spend down if they need nursing home care. They don't have to be probated. So again, no attorney fees or court costs. And last but not least, they are portable. So rather than signing an agreement with a local funeral home and being limited on the burial, if your mom or dad want to be buried back where they grew up, then this policy is good anywhere. So on that basis, funeral trusts make a lot of sense. So when it comes to providing a little peace of mind through pre-planning, estate trusts and funeral trusts are excellent options to ensure an inheritance for your family, as well as adequate funds for honoring your loved ones with a dignified burial in the event that they need protection from Medicaid recovery of their estate in their latter years. I hope that you found this presentation helpful. If you have additional questions and you would like to know more about these options and whether they're appropriate in your particular situation, then I would encourage you to start by clicking on the top link labeled Confidential Questionnaire and tell me a little bit more about yourself. And once you've completed that, I would encourage you to click on the link below Neil Angel's calendar to schedule a brief phone meeting with me to discuss your particular issues. I look forward to talking with you and I look forward to serving you more. Take care.